Let me hear you say ba 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 da ba 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 da ba 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 da ba 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 da ba 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 da ba 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 da ba 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 da. Crazy at this thing called love, just what I've been dreaming of. And I can never figure out, oh, how you do the things you do. Is why I'm so in love with you. I like the way you make me smile. Boy, you give me butterflies. And when I look into your eyes, I'll see the future in me and you. That's why I wrote this song for you. I-L-O-V-E-Y-O-U. I-L-O-V-E-Y-O-U. Just want you to know what I think of you. L-O-V-E-Y-O-U. Baby, you've got what it takes to make your girl say L-O-V-E-Y-O-U. If I met you in another life and you asked me to be your wife, with grace and a smile I say, yeah, always now and forever. You be my one and only lover. Cause I like the way you make me smile. Boy, you give me butterflies. And when I look into your eyes, I'll see the future in me and you. That's why I wrote this song for you. I-L-O-V-E-Y-O-U. I-L-O-V-E-Y-O-U. Just want you to know what I think of you. L-O-V-E-Y-O-U. Baby, you've got what it takes to make your girl say L-O-V-E-Y-O-U. Ba 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 da ba 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 da ba 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 da ba 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 da ba 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 da ba 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 da ba ba da.
Good morning, and welcome to Attorney Commander J.R. Glapohkpa Chesson talk show. The weekend is on us, and today is what? Saturday, April. Give me a break. I can't see. April the 15th, 2023. We woke up this morning to 50 plus degrees in Providence, Rhode Island. We see how the weather just going up and down, sometimes 60s, sometimes 50. Take heed and govern yourselves accordingly. Okay? The spring is on us. Let's get ready to enjoy the summer. Remember, seatbelts. Do not forget to put your seatbelts on. Okay? We see the situation of yesterday in the newspaper, where the Supreme Court of the Republic of Liberia came down with its ruling in the case of Liberty Party. Both Liberty parties, Musa Belity and Nombly Kanga Lawrence. So this is a long-awaited case. The court finally came down. I'm sorry, folks. I had a problem with my camera. Oh, Lord. Yes, it fell. My camera fell once or twice. I gotta go check it out. That's why I came on. I almost came on late this morning because I was trying to work on it. It fell and hit the table once or twice and was acting up. But anyway, let's go back to my lesson. The court resolved a situation. Now, the court rationale was based on the axiom or legal principle of res judicata. There are two situations, or I don't want to be precise. There are situations under which the court will use certain terminologies. And those terminologies have very serious consequences. They either stop the case from going forward, or they tell the judge, you can't hear this case no more. So to do that, they use legal axioms or words or jargons. And in this case, with the Liberty Party, the court based its rationale, the reason of the court for its decision on what we call res judicata. Another similar ruling is something we lawyers call stare decisis. They're similar, but they're different. Similar stare decisis, you plead it at the beginning of a case to stop the case completely because it means that the basis of this case is on a standing decision that has already been made by the court. It cannot go forward no more. So if somebody brings a case against you with the same issues, with the same principle, like this case, the same parties, everything, or similar parties, but the court has already ruled on the issues, on the facts, and all of that, it cannot be heard again in the court no more, because the court has made a decision on that case. And whatever decision the court makes on the case, it becomes a standing decision. What that means? It means that no other court can handle that case no more. The court has heard the case, dealt with the facts, dealt with the issue, made a decision. It's a stare decisis case. No other judge can deal with the issues of that case or the facts and everything. Okay? Then the other one, like this one that the court handled yesterday, it based it on res judicata. Now, res judicata, you can raise it in a motion, you can raise it in certiorari, anything to dismiss a case, especially to dismiss a case, you raise this to dismiss a case. Stare decisis, you can raise it at the beginning of the case to stop the case completely. This, you can raise it on a motion, in a motion or whatever, which the court did here in this, the court stated it was stare decisis. What is stare decisis? In this case, you got the same parties. It's the same, a decision has been rendered on the case. Okay? And let me make sure I do. You have a prior decision made on a case. The decision was made on the merits of the case. That means they went into the case. It wasn't procedural or other reason why the court would throw out a case because there's an issue or error with the procedural error or judgment error or some kind of error. The court would throw the case out. But when the court does the case on the merit, that means the case went through the court, and the court heard all the parties to the case, heard all the issues, and was not dismissed on any technicality. They went through the case, and the court made a decision on the matter. Okay, so the court, it was finally made on the error. The parties are the same, the issues are the same. Okay? So those are the four things that has to do with stare decisis on and similarly with res judicata. You have a prior decision made. The decision was made on the merits. The parties are the same. And the issues, everything the same. So it comes before the court. The same thing happened with Liberty Party. Now let's go through the case. Liberty Party went into the convention. We all saw that on the internet. They selected Mr. Ability. How did they do that? Via a white ballot vote. That means everybody voted unanimously to select Mr. Ability. Darius Dillon, Nomri Kanga, all of them did it. The voter Ability. Like Ability stated in one of his statements, he didn't know too much about the political laws or the laws of the NEC. That when you form a party, when you do your convention, you got 10 days to notify to the NEC of your constitution, the officers and all that. He didn't know that. So he sat down for over a month. Then when the NEC finally said, hey, my man, where are your documents? They went and filed. That's when all this commotion came about. Ability not the right man. He's not the right leader. It wasn't this convention, it was another convention, and all of that. So when all this confusion came about, the NEC tried to resolve it. Normally, Kangaden alleged that the National Election Commission was working with Musa Ability Fashion. Why? Because in one of their letters correspondence to Musa Ability, they referred to him as the secretary or the chairman of the collaborating political parties. By that time, you remember, they had these collaborating political parties and Liberty Party, all of them were part of it. But it was during that same period of time when this party was coming together, the CPP was in the process of bringing itself together. After Brennan Ayew led it, I think normally led it to for Liberty Party, then Cummings led it. Then when they got to boycott time to lead it, that's when all this fuss came about fraudulent document right in the CPP. And at the same time the CPP were doing theirs, Liberty Party, Musa Ability, Nomri Kanga, Darius Della, all of them started to have their confusion. Okay? So Nomri Kanga and her group filed a complaint with the NEC, with the National Election Commission, alleging that the Election Commissioner was colluding with Musa Ability to violate the rules and all of that, and that Musa Ability was not the right man to be leader of the party, and that Nomri Kanga, who was the political leader then, they had made a decision to break away from CPP. So there was no way that Musa Ability could be with the CPP. So all of this was going on, and what else they alleged? And they alleged that, oh yes, the whole case was based on Article 5, Section 5 of the rule of the Election Commission. We stated that the Election Commission cannot accept false information from any official or anybody in the party or anything like that, something like that. Okay? So those were the issues that they filed this case on. The NEC, the hearing officer went through the case and dealt with everything, and he sided with Musa Ability. NEC and normally Kagaran didn't like that. They appealed it to the full board. So they went to the full board, the board looked at everything, and the board said, no, the officer did not err. Whatever the hearing officer did was correct, and he did the case on it was correct, and he and normally Kagaran didn't have any issue. So they should go back and let the hearing officer complete the case. So that was they stood. The guy did his judgment, everything, and I think they all sided with Musa ability for the time being. Normally Kanga didn't like that. So they took the case further. They appealed to the justice in chambers, who were Justice Yusuf Kaba, on a rate of certiorari. Now, what is that rate? That rate is a rate of review. Okay? It comes from the appellate court. It's discretionary. The judge can grant it or he does not have to grant it. Okay? It's not something that he's compelled to do. Because they want him to review the case, they're not appealing the case. If they had appealed the case, that would be a different issue. But when you say, hey, we want to rate a certiorari, that means we want you to review the case. We want you to look at all the issues, all the facts. Only an appellate court can review the case of a record, the court of records of a lower court. So this is what the appellate court did. Justice Yusuf Kaba decided to accept the case for review. So he accepted it. He went through everything and decided, he went through all the merits and decided that the case should be in Nomdi Kangaden's favor. And he made notations and sent it back to the Election Commission to try the case on the issues that he sent. You know, and among the issues that they were dealing with had to do with the constitution of the organization, that the crux of the issue. They were saying that Musa Ability could not be the chairman of the organization because he wasn't, they had a problem with their convention. They were trying to say one convention said this and the other convention said this. So Musa Ability did not have the authority to take the constitution and file it with the NEC for the party, and also that he tampered with it. It was fraudulent. So when the case was taken up by Yusuf looked at it on the merits and sent it back to be changed and in favor of Yomni Kanga, but the basis of the case rested on the constitution. And Musa Ability was saying, no, you can't do that. You can't send the case back to NEC to hear the case on the constitutional issue. Any instrument, the court say any instrument that deals with the constitution has legal ramifications, got to be there with the court. So he was sending the constitution and everything back for the NEC to act on. And Musa Ability said, no, you can't do that. So Musa Ability filed a writ a petition for a writ of prohibition, which is to stop the whole process. To say, no, stop the process. The court got to review this thing. This thing is not right. So they stopped the process and he appealed. Sam, my correspondent, just came in. Sam, I'm talking about the case this morning, okay? So he appealed. I can't hear you. I'm talking about the case. So he appealed Musa Ability petition for a writ of certiorari to the Supreme Court. He filed for a writ of prohibition to start the case. Then he filed to the Supreme Court a writ of certiorari too, so the court can review it. The Supreme Court can review it. So with all that combobulation, this case had gone on for 2 years almost. So the court got tired because they said, okay, bring it, let me review it. So the case went to the Supreme Court for review. The Supreme Court looked at all the merits of the case. Let me tell this man, he coming on just now. Sam? I can't see. The Supreme Court dealt with all the issues of the case, all the merits of the case. And that's where it came out with all these issues. This case was heard in the, hold on a minute. Sam? Hello? My boy can't hear me, bro. So this case was heard in the NEC, which is a quasi-lower court. And the appeal from that, they didn't appeal, that's the problem about it. They went by via writ of certiorari of review to the court. So the court is saying that, yes, Judge Kaba, you review the case, Judge Yusuf Kaba, who is the judge in chamber, review the case and send it back. But the issues of the case, the crux of the case is the Constitution. And NEC does not have the authority to deal with constitutional matters. When anything that has to do with legal documents or Constitution, only the court has the authority to do final adjudication on that. Sam? I don't know if you're hearing. To do final adjudication on that. So the matters that NEC deal with, they should not be appealable. They should be final issues. Okay? Especially when they deal with constitutional issues or legal issues. So,
Yeah, network problem, man. Let me help.
Yeah, right now. So come back later on, we'll talk. Come back in about 10, 15 minutes. Let me finish with the case. Then we'll talk about situation in Liberia, okay? The case from yesterday. So that's what the court was saying. The court saying, no. Secondly, because you file a document, you are responsible. You not the information the court talking about when they say people from parties cannot, officials from alliances and different things cannot give false information. That means in cases, general information the NEC wants to know, but it's not talking about filing of documents, because when parties file the documents, the court does not expect the NEC to go through every document and call the people to verify that the document is, they read the document. That's not what they're talking about. You can't place that kind of duty on the NEC. You place that duty on the NEC, it will be all burdensome. When your officials present the documents, that's why we appoint officials, we elect officials, so we can repose trust and confidence in our officials. So when we give them responsibilities, and when they do their responsibilities and give documents to organizations that their organizations are a part of, we expect that those documents will be correct. We don't expect that people will go elect criminals in their organization and entrust them in big positions of trust where they got to make decisions for the organization with or without committees. Then you're telling us we must be responsible for your own people. You don't trust your own people? Every time your people submit documents to us, we must go through each document for clarity and understanding. No, the court said, no, that's not NEC job. Because 5.5 of the rules of NEC says that officials belonging to alliances, groups, and things cannot give false information. That does not mean that any information or document your organization gave to the NEC got to go through it and call everybody in your organization to make sure that this is true and this is verifiable. No, the court said no. That's asinine. You appoint officers. You're supposed to have some level of trust and confidence in your officers that they will do what you want them to do. They will not sit one night and falsify documents and change documents. So the court said, no, they're not dealing with that aspect of this case, that 5.5 rule. They're not going to hold the NEC to it. But what they want to do is they want to make clear that organizations like the NEC that are repositories for documents, for political and issues and all of that, they have no connection with the law. So they cannot impugn any legal ramifications or issues in their board meetings, in their cases. They can't deal with constitutional issues. So if there are issues there that normally Congress felt were constitutional, they should appeal. They should appeal from that court. But they did not appeal. Instead of appealing, they asked for a review. So the court reviewed it, and that's where they messed the case up. Because they asked for a review and dismissal instead of appealing the motion from the decision of the NEC. They should appeal. If they appeal, then the court will look at the constitutional issue and decide on the overall issues. So they didn't appeal. So you got to appeal, and they got to count the decision. You got to appeal to a court of competent jurisdiction. That's how jurisdiction over the court. They keep talking about competent jurisdiction. What is competent jurisdiction? That means the court got to have subject matter jurisdiction and jurisdiction over the parties, over everything. Then it has competent jurisdiction. Okay? Sometimes you can go file a case in another county, and I'm living in this county. My county have no connection to that state or state. I'm not going to that state. That state has no jurisdiction over me. So over the case itself, the court will not have competent jurisdiction. They may have jurisdiction over the subject matter over one of the parties, but not all of the parties. So there's no competent jurisdiction. But this case was brought to a court of competent jurisdiction. It had jurisdiction over the parties, the subject matter, the issue, the facts, everything. Okay? So with all of that before the court decided. The hearing officer and the board heard the case. They dealt with all the issues. They did an extensive review of the case on the merits. Because when you went to the board told the guy, the hearing officer, to do the case on the merits. And he did the case on the merits. So that means they look into all the issues. So from the NEC, they look at all the constitutions. The hearing officer look at all the constitutions because they said that they had different conventions. I don't want to get into the party business, but it was a conglomeration of bullshit. They said they had one convention in February, one convention in December, and all of that. So the court had to look at all of that to determine which convention was the right convention, which convention gave Musa Belete the authority to do what he did. Because if you do not have the authority as the chief administrator of the party, you cannot file documents. And under the Constitution of Liberty Party, they had two constitutions. So the court look at the hearing officer look at the one from 2015, I think. That was 2015 Liberty year. The Constitution of 2015. And in that constitution, you see, they changed the Constitution. That was the issue. Because the Constitution of 2015 said one thing, and the other Constitution that they had later took powers away from the same chairman. So when they elected Belete chairman at the convention in 2015, under that Constitution, Belete had the power to do things as the chief administrator of the party. That means he ran things for the party. He had implicit trust. He was in a position of trust, a fiduciary position. You don't just elect Zogos for those positions. When you elect people for those positions, you don't come behind them with a magnifying glass and check on everything they're doing. No, you don't do that. Those people have authority. Those people can do certain things for the organization without the board, without the committee. When you are the chief administrator, you run the show. You can even call the board together or dismiss the board if the Constitution permits that. So the court said no. The hearing officer did the case on the merits. And when he did the case, one of the things he found out was that of all the constitutions you're complaining about, the 2015 Constitution was the legitimate constitution of Liberty Party. And in that constitution, it gave Musa Belete the authority to be chief administrative officer. That means he could file the document with the NEC for Liberty Party. So Musa Belete filed the case. And that was one of the crux issues of the case. All of us remember it because I remember it. They were talking about the convention. Oh, well, this convention, and we went to the and Dawa normally Kanga and Darren's Dylan broke away for because they didn't because Musa Belete suspended them for misbehaving. He suspended them, and that's why they went to the court. You see, because when they filed the case first, and the board decided the hearing officer, they took the case from the hearing officer and went to the board. When they got to the board, and the board decided for Musa Belete suspended all of them. That when they took the case to Yusuf Kaba, and he turned it around in Nyomli Kanga's favor and sent the issue back. But he dealt with the issues too. His issue was res judicata too, because he must have determined some kind of issue in the case. But he wanted to give it to Nyomli Kanga because he was dealing with another constitution and whatever they were dealing with. He sent it back. He sent it back then and wanted them to change certain things in it. That one Musa, but they said, no, you can't change it because the whole crux of the matter rests on the Constitution. Only a court of competent jurisdiction can deal with constitutional matter, not the NEC. So if Judge Kaba didn't deal with that issue, he can send it back to the court to change it for the NEC to favor Nyomli Kanga on the constitutional matter. It can't be. That when he filed a writ of prohibition to stop it. They said, no, it's not right. Then while he was there, he filed another writ of certiorari to the Supreme Court. So the Supreme Court can look at everything. And that's when the Supreme Court said, well, we'll look at it now because This case been going on for too long. It's been through the NEC, been through the judge. Let's put this thing on the record and end it. Okay? So the second point they raised was the convention of 2015 was a valid and official convention. The court said that the NEC came to the conclusion on the merits of the case that convention of 2015 was a valid convention. So because it was a valid convention and Musa Belete was made chairman, he had the authority to act on behalf of the organization. And Article 5.5 of the NEC law or rule does not mean that the NEC got to go through every document that a chief administrator submits who has the trust of the organization reposed in him. When he submits that document, the NEC does not have to go through it with a pin, with a needle, a pin, or toothpaste, or magnifying glass to make sure it's truthful and correct. They don't have to. The party put the trust in the man. You know? And the court also said on the issue of the constitutionality of what Musa did, that was not the NEC duty to look into constitutional analysis of the issue. Whether normally raised it or not, they should have tuned it out. But that wasn't the business. Only a court of competent jurisdiction can deal with legal matters and legal documents. Constitutions of other organizations are legal documents. So when normally raised it in court and the NEC took the time to listen to it, it was wrong. It was totally wrong. The court said, no, you should not entertain that at all. NEC is a repository of documents, political parties, and different things. A repository is a place where they keep things. It's not to act on things. It's to ensure that whatever is kept in there is concise and correct. So it's a repository, a building to keep things. You see, it can't act on the law. It can't go beyond its duty, then it's usurping the powers that are not given to it. So the court said, man, you just a repository of political documents, parties, and political parties and all of that. You can't deal with constitutional issues or legal issues. Okay? So the court said, NEC was wrong for even looking at it. And what is even more is exciting, the court said the CPP not there, Ella Cummings, Benana Ure, Joe Borga, that CPP not there. The court said not there. Why? Because Liberty Party Executive Committee made the decision for Liberty Party to join the coalition of political parties. And when they join it, nobody else can break that order except the Executive Committee of Liberty Party. And the Executive Committee of Liberty Party has not made that decision yet. So Liberty Party is still a part of the CPP. So whether that Eric Cummings CPP so the NEC was not wrong for writing that letter to Musa Belete as Secretary General of CPP indirectly. That's what the court is saying too. The court say, hey, you're still with the CPP. Let me just make that right for the record. Because you're blaming David Edward Brown for writing Musa Belete under the caption of CPP. But let me surprise you right now. CPP is still in existence for Liberty Party, where Liberty Party is concerned. Because Liberty Party merged with the CPP because of the order from the Executive Committee. And that order still stands. because this executive committee has not rescinded or revoked it. So the order still stands. So the court saying now, this case is res judicata. It has been dealt with. Decision has been made on it. The court will not tamper with it. The court just reviewing it and explaining it to you all. You see? But once the court say res judicata, that means it's not dealing with it. Everything is rest. It's going to rest. The issues, the parties, it has been dealt with. It's not dealing with it no more. So Musa Ability is the man right now for the party. So as you can see on all the other shows, they've been talking about how they can reunite the party and do away with all their problems. But the whole crux of this case is the court is saying the NEC dealt with everything. The only problem the NEC had with this case, they should not put themselves in the constitutional matter that nobody can get and raise. They should not have dealt with it. They should have said, no, we're not dealing with it. Take that somewhere else. We're just dealing with the case on the merits. Who is the rightful person to file these documents? Who filed these documents? Were they filed correctly? Was Musa Ability the right authority to file these documents? And the NEC rested on that. They say, yes, he was. He was, because he was the chief executive administrative officer of the party. And because the Article 5, Section 5 of the rules here, they can't, people can't give false information. That don't mean that Musa Ability gave false information. He didn't make any statement to them that was a lie. They didn't ask him, for any information. He gave wrong information. No. Everything just boiled down to the fact that the case has been decided. All the major issues dealing with the convention, dealing with selection of the leadership, dealing with who could file papers with the NEC from Liberty Party, those issues have already been dealt with by the NEC board, because they appealed to the board and the board dealt with it. Now, instead of appealing from the board to the Supreme Court, because that matter was an election matter. You remember what the court said? The court said any matter that goes through the NEC to final adjudication is an election matter, and the court will hear it. So NEC should appeal. Instead of filing a writ of certiorari for the court to review the case, they should have filed an appeal for the wrongful decision of the NEC to deal in the constitutional matter of the party. It may not have changed much because you still got the issue of res judicata. And once the issue of res judicata is there, everything has been dealt with. So that's where we are. Okay? The court saying that Liberty Party case that went to the NEC, all the issues on the merits were dealt with. All of them were dealt with. And they were not going to any other issue. Why? Because this is not an appeal. They did not appeal it. They just wanted a review of it. And the court reviewed it. They saw it, they looked in the merits of the case as it was dealt with. Because what the court did, when you file a writ of certiorari, the court, the upper court, tells the lower court, bring all the records. It's like the case starting anew, because you bring a new case on that one issue for the court to review it. So the court is like starting anew on that one issue. So the court would call down to the lower court and say, hey, buddies, bring all the records. We need the records. Bring all of them. Then the boards will put all the records together and send it to the court. And the judge will sit down there and review all the records again, because he got to decide on that case now. And that's what the judge did and sent it back. But he did it for Yomli Kanga, Yusuf. And Musa Belete had a smart lawyer. They jump on our keys. And, no, we're not doing that. We're appealing this thing, okay? But anyway, that's the case for the day. Musa Belete is the man. Let me put him back up here so we can see that he is the man. Oh, my topic for the day. I forgot to put up my topic for the day, my people. My topic for the day was telling you the responsibility of who are the people in our judiciary. These are legal technocrats. That will make the law, the study of the law, different from other social degrees. People can get master's degree in English, master's degree in science, biology, but when you go to law, you're studying the whole process over. You see, with me, I got an LLB. I'm a Bachelor of Law degree. We follow the English system. Our degree is not the JD. That's why I had a hard time taking the bar exam, because I didn't have the time to memorize the stuff. You must take up at least 2-3 months to memorize it. It's all about memorizing. I didn't have that time. But that's the difference. The GED is to prepare you to go to court. You learn the law, the bare crux of the law, to go to court and plead for people. LLB, what I have, is intellectual. We learn the law to teach. We learn the law to do debates and intellectual competitions. And we learn the law to change it too. We are the people who deal with rationale and understanding the law and different aspects of the law. So you got one group of people that just take the bar exam and learn the law to make money. Those are the lawyers to go there and challenge the court and see how good they are in there. Then you got the other group of people that we got two choices. You can either go to court, we can go teach, we can go lecture, we can write books, we can challenge the legal system. That's people like me. Okay, so that's why my training is broader than the JD. And JD, people with Juris Doctor degree, that's not PhD. That's just a Juris Doctor degree. It's like an LLB, like my degree, LLB. Okay, but we don't want to be called Juris Doctor. Juris Doctor, I mean, you study just to go to court and be a doctor on that issue. But we don't do that. I studied to teach. Right now, what I'm teaching you right now is part of legal practice. I'm teaching you the law. Once I'm teaching the law, I'm practicing the law. Okay? It doesn't have to be in a formal classroom setting. I have a show where I teach people the law, teach people how to do to prevent themselves from going to jail, analyze legal issues. So all those things make it the practice of law. So that's my class for this morning. For all of you people who didn't understand the judgment of the court, all the court is saying, we can't hear that case as it is. That case has been dealt with already on the merits. But the court itself, the Supreme Court itself, had work to do, because they had to take the record from the lower court. Before the Supreme Court even reviewed the case, they had to tell the NEC, send all the records up here. Let me see it. Because that was a new case. Once they go up there and they call the records up, that's a new case. Because they got to go through all the records to make sure that they understand the situation in the lower court and what was taking place in the lower court to make the decision. So when they send for the court, that's a court of record. They say, give us all the records. They look at all the records. Then they made a decision. Okay? So that's work too. Because all of them, they got to sit there, look at all the issues, look at all the different things the hearing officer said, listen to the hearing officer case, listen to the board decision based on the hearing officer complaint and all of that. See why they decided to side with the hearing officer, and yet why ability appeal to put down prohibition. Look at all of that too. So when they did all of that, they came to the conclusion that, oh, this case has been resolved, man. We ain't going to it no more. If y'all want to go into it, you should have appealed it. If y'all have appealed it, then you'll open a new can of worms for us to look at the constitutionality of the matter. Then we have to deal with that case on the merits too. But y'all didn't appeal it. You see? So, and we're not getting into it because all the major issues have been decided. Okay? There was a prior decision. The decision was final. It was on the merits. It was with the same parties. It was the same issue. The Supreme Court will not deal with it no more. Stare decisis? No. Res judicata? Yes. Aluta! Continue. My class is done. So that's it. If there's other issues, maybe you can bring it up. But it's just that the court is saying that. Let me see what my boy got to say. He finally came back on. They're having a lot of weather problems. Sam? Oh, yeah.
Yeah, man, the network give me hell, man.
I know. That way you didn't come on.
I'm ready to somewhere around. Yeah, man, the network, man, StreamYard is giving me all kind of problems, all kind of questions.
What do I ask you?
Hello?
What kind of questions? It's so bad. Well, ladies and gentlemen, Sam, my correspondent is having a problem with weather problem issues in Liberia. So that's it for today. My class is done. I hope I explained everything that you could and you understood it. If you didn't understand it, please put all your notes here. I will go through it and I will come back and make a notation what the comments supposed to be. I'll check it out. And tomorrow, next week, I'll deal with it. Okay? I was so busy I didn't put on my hat and my thing. I was rushing. I want to make sure I start at 6 o'clock. Okay? Because when I don't start at 6 o'clock, people be calling me, oh, Chesson, you didn't start at 6. Oh, you didn't start. No. Okay? I wasn't sleeping. I wasn't tired. I was just busy. Take heed and govern yourselves accordingly. Internal Commander Glapohkpa Chesson class is done. I'm out of here. Have a good day, my people. See you next week. Don't do what I wouldn't want you to do. Be safe.